You cannot walk around life without, at the minimum, having a high school diploma. You and I are going to work on that together. And if you don't, I will put you over my knee like a little child and I'm going to spank you with a ton of jail time. Do you understand?
Three defendants, three completely different stories, and one judge who's about to deliver some of the most memorable warnings you'll ever hear in a courtroom. Today, we're breaking down a triple header of cases that showcase the full spectrum of criminal justice. From domestic violence, where the defendant literally said, "I got her a ring, so I can do whatever I want to her," to an 18-year-old caught with Xanax who's about to get a reality check about his future, to a treatment facility brawl that involves hot coffee, mutual combat claims, and a probation violation that's landing someone back in custody. We got a judge who threatens to spank defendants like a little child, with jail time if they don't get their GED, a mother desperately trying to keep her son on track while he heads to college orientation, and a defendant who insists he was defending himself against coffee burns while living in a treatment facility. From protective orders and GPS monitoring to drug testing threats and educational ultimatums, these cases reveal exactly how judges balance punishment with rehabilitation, safety with second chances, and tough love with actual consequences. Buckle up, because this courtroom session is about to get intense, emotional, and brutally honest. Let's dive in.
You're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 7, 2024, witness 1 stated that he observed the defendant arguing and then striking the complaining witness with a closed fist to her head. The complaining witness is the girlfriend of 5 years. The complaining witness fell to the ground and then the defendant hit her in the face again. Witness 2 tried to intervene, telling the complaining witness to run, and then running into the Kroger asking for security. Once security was outside, the defendant threatened security to ignore what was going on and to mind their business. Witness 1 called the police and the complaining witness walked away from the scene. The defendant struck the complaining witness again with a closed fist to the head as she was walking off. The complaining witness stated the defendant was intoxicated and did not want the defendant to go to jail. The complaining witness admitted to the defendant striking her. However, she retracted her statement once the situation was likely leaning towards the defendant being in jail. The complaining witness does not want to pursue charges and refused to cooperate in regard to her injuries. Law enforcement officers observed bruising on her right cheek and neck area of her head. The complaining witness advised she would remain in contact with the defendant and the defendant stated, "I got her a ring, therefore I can do whatever I want to her."
I got her a ring, so he can do whatever he wants.
Stop right there, because what you just heard is one of the most chilling and disturbing statements I've ever encountered in a domestic violence case. I got her a ring, therefore I can do whatever I want to her. Let that sink in for a moment. This defendant genuinely believes that giving someone an engagement ring grants him ownership over her body and the right to commit violence without consequences. This is a textbook mentality of an abuser, viewing a partner not as an equal human being, but as property that can be controlled, dominated, and harmed at will. Now let's break down what actually happened here, because the facts are absolutely horrific. We have multiple witnesses who observed this defendant strike his girlfriend of 5 years with a closed fist to her head so hard that she fell to the ground. Then, while she was down, he hit her in the face again. Bystanders tried to intervene, telling her to run, and seeking help from Kroger security. When security arrived, the defendant threatened them to mind their business and ignore what was happening. That's consciousness of guilt right there. He knows what he's doing is wrong, which is why he's trying to intimidate witnesses into silence. But here's where domestic violence cases get tragically predictable. The victim initially admits he struck her, but then retracts her statement once she realizes he's going to jail. She explicitly states she doesn't want him arrested and refuses to cooperate regarding her injuries, even though police documented visible bruising on her cheek and neck. This is a cycle of abuse in action, violence, followed by victim recantation driven by fear, financial dependence, emotional manipulation, or trauma bonding. The fact that she says she'll remain in contact with him tells us she's likely going back to her abuser, which puts her at continued risk of escalating violence.
And I've got your bond, so I can do whatever I want. And I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication, and not to have contact with this person. Do you understand? I'm now issuing what's called a magistrate's order for emergency protection that identifies Lindsay and Edmund as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Threaten, harass, use another person to communicate a threat or harassing behavior. You can do none of this. No weapons or no going within 200 feet of where she lives or where she works. You understand? You violate these conditions, the state can and will file a violation of a protective order against you. As it stands now, Mr. Aris Mendez, no alcohol, no dope, and no contact. Otherwise, I'm going to put you in jail and I'm going to make your bond sky high. Do you understand me, sir?
Yeah.
The judge just issued a magistrate's order for emergency protection, and this is one of the most powerful tools courts have to protect domestic violence victims, even when the victim herself doesn't want protection. Let's break down exactly what this order means and why it's so critical. First, the defendant is prohibited from consuming alcohol, which makes perfect sense given that the victim stated he was intoxicated when he assaulted her. Alcohol is frequently a contributing factor in domestic violence, lowering inhibitions and escalating aggression. Second, he's under a strict no-contact order, meaning he cannot communicate with the victim in any way. No calls, texts, emails, social media messages, showing up at her home or workplace, or using third parties to relay messages. The order specifically references section 42.072 of the Texas Penal Code, which is a stalking statute, meaning any pattern of following, surveilling, or repeatedly contacting her could result in additional criminal charges. Third, he's prohibited from possessing weapons and cannot go within 200 feet of where she lives or works. This creates a buffer zone designed to prevent him from intimidating, threatening, or re-assaulting her. Here's what's crucial. Violation of this protective order is a separate criminal offense. If he contacts her, shows up at her residence, or threatens her in any way, prosecutors can file charges for violation of protective order, which carries its own penalties, including jail time. The judge makes this abundantly clear with his warning. No alcohol, no dope, no contact. Otherwise, I'm putting you in jail and making your bond sky high. What makes emergency protective orders so important is that they're issued immediately at the defendant's first court appearance, before full hearing can be held. They provide instant legal protection, even when the victim is reluctant to seek it herself.
Does he have any prior criminal history? The bond is set high for someone who, that's why, please, if you can run an NCIC, because the bond is higher than what normally would have, someone would have with no criminal history.
We can't speak on the bond decision, Your Honor, but with regards to his
No,
history.
nothing? Okay. How old are you, sir? What do you do for a living?
Select that work at a warehouse.
How much money do you make a month? Who do you live with? Did you graduate from high school? Now we're going to start working on that. I will give you a lawyer today. You have 2 weeks to figure out how we're going to get started to work on getting your high school diploma. You must get online, start researching how to get your GED. I want you to do that. You come back in 2 weeks. If you've done nothing, life for you is not going to go well with me. You get my drift.
Now the judge shifts from imposing protective conditions to addressing something that might seem unrelated, but is actually deeply connected to criminal behavior: education. When the judge discovers that the defendant didn't graduate high school, he immediately makes it a condition of the defendant's release that he work toward getting his GED. This might seem unusual in a domestic violence case, but it's actually brilliant judicial thinking. Research consistently shows that lack of education is strongly correlated with criminal behavior, unemployment, poverty, and substance abuse. People without high school diplomas have significantly higher rates of incarceration, lower lifetime earnings, and fewer opportunities for stable employment. The judge understands that if this defendant is going to break the cycle of violence and criminal behavior, he needs the tools to build a different life, and education is foundational to that. Notice the judge gives him a specific timeline: 2 weeks to research how to get his GED and start the enrollment process. He's not just making a vague suggestion. He's creating an actionable, measurable requirement with consequences for noncompliance. The judge will verify at the next hearing whether the defendant followed through, and if he hasn't, The threat is clear. Life for you is not going to go well with me. This approach reflects a rehabilitative philosophy of justice rather than purely punitive. Yes, the defendant needs to be held accountable for assaulting his girlfriend, but punishment alone doesn't prevent future violence. Giving him education, job skills, and better life opportunities creates pathways away from criminal behavior. What's also significant is that the judge is willing to provide resources. He mentions that the court has services to help defendants obtain their GEDs, and he's appointing a lawyer who can connect the defendant with those programs.
You have 2 weeks to start researching how to get your GED, to get your high school diploma. You cannot walk around life without, at the minimum, having a high school diploma. You and I are going to work on that together. And if you don't, I will put you over my knee like a little child and I'm going to spank you with a ton of jail time. Do you understand?
Yeah.
So if you have any, let me ask you this. Do you have a computer? You don't have a computer. Okay. How do you access the internet? So you have a cell phone. Okay. Use your cell phone. And within 2 weeks, I want to see what you've done to register and look for classes. If you have any issues, I'm going to give you a lawyer today. And we have services that can help you if you need to get your high school diploma. We are going to do this one way or the other. It can either go the easy way or it can go the hard way. Do you understand? Okay. I already have an application on file. For now, I'm going to have you go to Victoria. We're going to have you sign a reset. After that, you'll get retraced for your bond conditions. No more dope, no more alcohol. Do you understand me? Okay.
The judge's language here is absolutely memorable. I will put you over my knee like a little child and spank you with a ton of jail time. It's colorful, it's direct, and it communicates exactly what's at stake in a way that's impossible to misunderstand. But beyond the vivid metaphor, what's happening here is a judge is removing every possible excuse for noncompliance. The defendant says he doesn't have a computer. The judge immediately asks how he accesses the internet and discovers he has a smartphone. Problem solved. Use your phone to research GED programs. The defendant might claim he doesn't know where to start. The judge is appointing a lawyer and offering access to court services specifically designed to help people obtain their diplomas. Every potential barrier is being addressed proactively. This is what effective judicial supervision looks like. Setting clear expectations, providing the tools and resources needed to meet those expectations, eliminating excuses, and establishing firm consequences for failure. The judge isn't setting the defendant up to fail. He's creating a roadmap for success and making it clear that following that roadmap is non-negotiable. What's also significant is the judge's framing. We're going to do this one way or the other. It can either go the easy way or the hard way. That's giving the defendant agency and choice. He can comply voluntarily, take advantage of the resources being offered, and improve his life circumstances. Or he can resist, ignore the requirements, and face jail time. The outcome is entirely in his hands. This approach is rooted in procedural justice theory. The idea that people are more likely to comply with court orders when they understand the reason behind them, feel they've been treated fairly, and believe they have some control over the process.
No, Your Honor, he's 18. His mom is here in the courtroom. Do you want her up here?
Yeah.
I have an attorney, but I don't know where they are.
Yeah. They're always running late. Don't worry. I know them well.
Oh, right.
Good morning, Mom. Thank you for coming. You are, is it Lonan?
Yes, sir.
Lonan? Mr. Russing, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 7th, 2024, officers were dispatched to an address regarding a suspicious vehicle and observed the vehicle stationary at a dead-end street. Officers asked the defendant what he was doing, and he said chilling and hanging out. Officers smelled a strong odor of burned marijuana emanating from the vehicle. Officers conducted a pat-down and located a THC pen in the defendant's pocket and a glass cylinder-shaped bottle with 5 white square pills that were Xanax. The defendant did not have a prescription bottle or prescription on him. It was 16 grams of Xanax.
Now we're moving to our second case, and the contrast couldn't be more striking. We got an 18-year-old kid who just graduated high school, is about to start at the University of Houston, and his mom is sitting right there in the courtroom watching this unfold. This is every parent's nightmare. Your child is on the verge of starting college and building their future, and suddenly they're facing criminal charges that could derail everything. Let's break down what happened. Police found him in a stationary vehicle at a dead-end street. Classic suspicious behavior that's going to draw police attention. When asked what he was doing, he said, chilling and hanging out, which immediately raises red flags, because why would you be parked alone at a dead end doing nothing? Officers smelled burned marijuana, which gave them probable cause to search, and they found a THC vape pen, and this is the serious part, 16 grams of Xanax pills without a prescription. 16 grams is not personal use. That's a significant quantity that suggests possible distribution. Xanax is a Schedule IV controlled substance, and possession without a prescription is a criminal offense. But here's what makes this case different from typical drug possession cases. This kid has his whole life ahead of him. He just graduated high school. He's been accepted to a major university. He has a job at a restaurant, and he's got a mother who cares enough to show up to court and advocate for him. The judge immediately recognizes this and shifts into a different mode, not lenient, but rehabilitative and future-focused. What happens in the next few minutes could determine whether this young man becomes another statistic in the criminal justice system or gets the wake-up call he needs to turn things around.
So did they find a bunch of weed too, or any kind of weed, or?
No weed.
Mr. Rushing, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, guess what happens? Right. Very good. Mom, I'm in your hands. Anything else you want me to do?
We're going to orientation. No, that's
Okay.
Is this just like probation?
Well, let's not, I'll let your lawyer handle what's going to happen as far as, I know, they're always running late. Don't worry about it. My only concern is I want to make sure that he's not using while he's out.
I have a test at home that I'm going to administer, and I'm going to start doing that right now.
Don't worry about it. I have a better test. And I'm telling you now, Mr. Rushing, 31 days from today, I'm going to test you for weed. If you test positive, that tells me that you've continued to smoke, and I will put you in jail.
This exchange between the judge and the mother is fascinating because it shows the delicate balance between parental authority and judicial supervision. The mom says she has drug tests at home and plans to start administering them. She's clearly trying to take control of the situation and keep her son on the right path. But the judge politely but firmly establishes that his testing is going to be the standard that matters. He tells the defendant that in exactly 31 days, he'll be tested for marijuana. Why 31 days? Because THC can stay in your system for about 30 days depending on usage patterns. So if the test comes back positive a month from now, it means the defendant continued smoking after this court appearance. That's the judge's way of drawing a bright line. From this moment forward, no more drugs, and I'll have scientific proof if you violate. Notice the judge's tone when speaking to the mother. I'm in your hands. Anything else you want me to do? He's being respectful and collaborative, acknowledging that she's trying to help her son. But when she starts talking about what she thinks should happen regarding probation, the judge gently redirects. Let's let your lawyer handle what's going to happen. That's appropriate judicial boundaries. He can't have ex parte communications with family members about case outcomes, and he doesn't want the mother's expectations to get ahead of the legal process. What's really powerful here is the mother's presence and involvement. Research shows that family support is one of the strongest predictors of successful rehabilitation and reduced recidivism. This kid has someone who cares, who showed up, who's willing to hold him accountable. That's a huge advantage that many defendants don't have. The judge recognizes this and seems inclined to work with the family rather than against them.
As far as the pills are concerned, I'm going to randomly test you with that on an even faster basis. If you're using, likewise, you will go to jail. You will not get any more PR bonds. Perhaps it's a little jail that may cure him. You know, the problem is that you're now only 18. You're building your future. the more criminal cases you put on your background or on your record, the more difficult you just make it to get a job. And am I boring you, Mr. Rush?
Yes.
Look at your mom. Think it's easy on her?
I'm listening to you, sir. Like, absolutely.
This is one of those moments where judicial wisdom and life experience really shine through. The judge delivers a reality check that every young person facing criminal charges needs to hear. You're 18 years old. You're building your future right now. And every criminal case you add to your record makes your life exponentially harder. This isn't just a lecture. It's the truth. Background checks are standard for employment, housing, professional licensing, college application, financial aid, and even volunteer opportunities. A drug conviction on your record can disqualify you from student loans, certain jobs, professional certifications, and housing. The judge is trying to make this kid understand that the choices he makes today will follow him for decades. Then comes a powerful moment. Am I boring you, Mr. Rush? The defendant must have looked distracted or disengaged, and the judge immediately calls him out. Then he says something that hits hard. Look at your mom. Think it's easy on her. That's emotional accountability. It's not just about legal consequences. It's about the people you're hurting, the people who love you and are watching you throw away opportunities. The defendant quickly responds that he's listening absolutely, and you can tell the message is sinking in. The judge's mention that perhaps a little jail might cure him is a strategic warning. He's saying, I can give you a chance to turn this around voluntarily, or I can force the issue by incarcerating you. Which do you prefer? The mother's presence makes this even more powerful because the judge can appeal to family responsibility and shame in a way that might be more effective than pure punishment. This is therapeutic jurisprudence in action, using the court process not just to punish, but to motivate behavioral change through accountability, family involvement, and future-focused thinking.
Did you graduate from high school?
Yes.
What are you doing now?
I work at Pappy's Cafe. It's like a restaurant.
And yes, you have H orientation today.
Yeah, I have college orientation as well.
Where are you going to college?
Going to University of Houston.
I graduated from there. It's a great school. The more you put into it, the better you're going to get, like anything in life. Okay. So if you find that he's become a problem to you, just come back, talk to me, and I'll straighten him out for you. Anything you need, really. You know, the problem is 18-year-olds, they act like they can rule the world. They know everything, but yet. So be careful. Don't pick up any new cases. Does he have a license? Okay. He has insurance, I suppose. Okay. I will waive your appearance so he doesn't have to mindlessly come back to court, but you just have to stay in touch with the lawyer, and then they'll tell you if and when you have to come back. For now, I'm going to have him sign a reset with Victoria. He's going to meet with Tracy for his bond conditions, and then we'll just have you waiting back for your lawyer. Okay? Yes, ma'am. Please.
What we just witnessed across these three cases is a judge who understands that justice isn't one size fits all. It requires balancing accountability with opportunity, punishment with rehabilitation, and protection of victims with pathways for defendants to change. In the domestic violence case, we saw swift and aggressive protective measures. No contact orders, emergency protective orders, alcohol restrictions, and stern warnings about bond revocation. The defendant's statement that he got her a ring so he can do whatever he wants revealed a dangerous mindset that required immediate judicial intervention to protect the victim, even though she herself was reluctant to cooperate. In the 18-year-old's drug case, we saw a judge who recognized potential and didn't want to see it wasted. Instead of throwing the book at a kid about to start college, he imposed strict drug testing, warned about future consequences, engaged a mother as an accountability partner, and even shared that he's a fellow University of Houston graduate. That personal connection matters. It humanizes a process and shows a defendant that people who walked his path believe he can succeed if he makes better choices. The third case involving the treatment facility assault showed how complex these situations can be when someone's already on probation, picks up new charges, and claims self-defense in a therapeutic setting. The judge had to balance the defendant's progress in treatment against the new allegations and probation violations. What ties all three cases together is the judge's consistent message. I will help you if you help yourself, but I will not tolerate continued criminal behavior. Whether it's requiring GED enrollment, imposing drug testing, or issuing protective orders, every condition serves a purpose, either protecting public safety or creating opportunities for rehabilitation. This is what good judging looks like. Firm but fair, demanding but supportive, holding people accountable while giving them the tools to succeed. So what's your take? Do you think the judge struck the right balance in each case? Should young offenders get more chances based on their potential, or should consequences be uniform regardless of circumstances? How should courts handle domestic violence when victims won't cooperate? Drop your thoughts in the comments. I genuinely want to hear different perspectives. And if you found this triple case breakdown as insightful as we did, make sure to hit that like button. Share this video with anyone interested in criminal justice reform and how courts actually work. And don't forget to subscribe for more in-depth courtroom analysis where we break down real cases, explain the legal reasoning, and show you the human side of the justice system. We've got more incredible content coming your way, and you definitely don't want to miss it. Thanks for watching, and I'll see you in the next one.